Okay, for those of you who remember what it used to be like when we had physical uh, breakfast seminars, this is the time when I would say to you, can you please grab your coffees and your chocolate croissants and take your seats, and perhaps one day we might be able to do that. But in the meantime, let me welcome you to the Sullivan and Worcester, what used to be breakfast seminar. This is the February one. Let me just give you a date for your diary, which is 25th of March is the next webinar that we're doing. And we're currently, unless you want to persuade us otherwise, going to look at some receivable structures, receivable financing structures that we were asked to look at following the January seminar. But this is the February seminar. It's entitled, as you can see on the screen, Structuring Financings Using Physical Commodities and Documents Representing Them, Some Issues and Potential Solutions. And I'm pleased to hand over in a moment to my partner, Simon Cook, who is, I'm sure, known to most, if not all of you. And he'll take you through some interesting questions, problems, and the like that we have met. You will see that there is a Q&A box. If you have any questions, please feel free to type them. If there's time available, we'll try and answer them online. If not, we can always get back to you. And apart from that, I see there's a chat line. Hello to those who've said hello on the chat line. So thank you very much. And Simon, it's over to you, please.
Thanks very much, Jeff. Good afternoon, everybody. Today's session is going to be looking at financings using physical commodities and documents representing them. Obviously, that's a very wide area to cover. So what we've done is taken some aspects of these matters to run over with you today. There's quite a lot to get through. Some of it's a bit of a refresher, some of it's an update, some of it's looking forward to what happens in the future. But essentially what I want to cover is the approach taken to structuring and risk in the context of both lending-based structures and also ownership-type structures. So we'll be looking at things particularly associated with the goods. Obviously, there are lots of other assets in the commercial chain, but I'm very much going to be focusing on matters relating to the goods themselves when looking at these items. So we'll be looking at some risks and issues and how you might deal with them, the role that other parties might play, either helpful or otherwise. And then we'll be looking at issues around security over goods, and then moving on to look at ownership structures as an alternative and looking at some of the issues around repo structures and the use of SPVs. And then lastly, I will be touching on electronic bills of lading and warehouse receipts and what the current state of play is really in regard to those for a short while at the end of the presentation. So moving on to the first part of the talk, it's looking at risk. Now, structuring, as I'm sure many of you know, is all about risk. And when structuring your transactions, whatever they are, you should be looking at them from the point of view of identifying all of the risks that are there throughout the life cycle of the deal. What are they? Who's involved? What are they doing? How do the goods flow and the money flow? And what are the potential pitfalls, the things that could go wrong at each stage? And obviously they will be different for different structures and different commodities, as we'll be looking at in a short while. Once you've identified what you feel the risks are, then it's a case of evaluating them. How likely are they to happen? And if so, what are the consequences likely to be? It's then a case of deciding where that risk should lay. Should it lay with the financer? Is it something that they've priced into the transaction? Is it something that should remain with the borrower or with another party? Who's best placed really to deal with the risk in question? And we should take note at this point that obviously the risk profile changes throughout the commercial transaction. So something which is a big risk early on in the transaction, may, once a certain stage has been passed, cease to be a risk. And all of that needs to be taken account when looking at the risk profile of your transactions. Once the evaluation has taken place, then I think it's a case of how do you deal with those risks, the ones that you feel are likely to happen and may have some sort of material consequence. So the usual mantra is eliminate, reduce, mitigate, or allocate. And in terms of what we mean by that, as an example, you may well have a situation where you're concerned that monies may not find its way to suppliers, which your borrower requires in order to do the transaction. And in that case, you could deal with that simply by making sure that that money is paid to the supplier direct from the financing, or if you're only financing part of it, that the balancing payment from your borrower is paid to the supplier prior to you making your payment. If you want to try and reduce the risk, that's really all about monitoring and having the right covenants and protections in the document to give you the ability to do what you want to do. Then in terms of mitigation, here we're looking at things like limiting damages and maximizing recoveries. A lot of that is to do with things like credit enhancement, acting quickly once you know things are going wrong, making sure you have the right triggers in your documents. And then lastly, allocation. As I said, can you allocate that risk to another party in the transaction, or can you put it off to an insurer or to an LC issuing bank if you're concerned about something like buyer credit risk? But the overriding objective of the structuring is really all about trying to make sure that there's a balance struck between the parties, what they're expecting, what they need, because ultimately you need to get a deal done. If you don't have a deal done, then it hasn't worked out. So moving on from that and looking at some of the different structures, I'm not going to go into detail on the structures themselves. I really just want to focus on the approach to risk and the risks that actually exist in relation to these types of structures generally. So I've listed 6 at the top of the slide: pre-export finance, prepayment finance, tolling on the one hand, and then pre and post shipment and warehouse financing on the other. I'm sure most of you are familiar with these structures, so I'm not going to go into them in detail, but clearly PXF and prepayment and tolling are funded at a different stage in the transaction, in the commercial transaction, to the pre and post shipment and potentially warehouse financing. Now, I asked the question, what about the goods? The reason for that is that typically in pre-export finance and prepayment financings, the finance documentation is less about the goods themselves, which is the main reason why I'm not going to be focusing too much on them as we look forward in the session. Obviously, there are goods that have to generate the receivable, and that's important, but it's basically taking a sort of seller risk, if you like, on the production of the exported asset to trigger the payment obligation of the buyer. So it's really seller performance risk and buyer credit risk that are the 2 main risks you're looking at there. On the pre and post shipment and warehouse finance side, there's a lot more focus on the goods themselves. They've obviously already been produced and are either sitting there waiting to be exported or left on the ship, or are just sitting in a warehouse somewhere and are going to be financed while they're being stored. So in terms of the risks that apply, as I said, the first 3 is very much about seller performance risk. Buyer credit risk is common to both. You rarely have security over goods on pre-export finance or prepayment tolling type transactions, whereas you would do almost certainly on the second group of structures. In those structures, you want much more control. It's much more about the logistics of making sure that the goods are retained in their present state, that they're available, you have security over them, you have control over them. And so parties like warehouse operators, collateral managers, and other third parties who can exercise control, like logistics providers, are employed in the transaction and can help with your structure. So as I said, I wanted to focus a little bit more on those structures that are all about the goods, the pre and post shipment and the warehouse financing, and look at those risks. And they really do relate to the other parties in it, the buyer for the payment and credit risk, and the parties who are doing the storage, transportation, perhaps even processing. We've certainly seen transactions where maybe there's warehouse financing, but partway through the finance period, they go off to be told, processed in some way before returning to the warehouse. And that covers the financing period. So we're looking at those sorts of risks. How do you deal with them? If you look at the credit buyer risk, obviously you've got the obvious answers of some sort of credit enhancement, letters of credit or guarantees. You may also be able to do it on a practical basis by spreading the risk with a multitude of buyers. It's unlikely they're all going to go and default under their documentation. But it's not just about financial status. It's also about the documentation entered into with that buyer. Do they match the terms of the financing? There's no point having payments due from buyers 6 months, 12 months down the line if repayment periods are quarterly from now. So it's a case of doing a bit of due diligence and making sure that the documents reflect the contracts. Quite often we get asked to review contracts which are potentially going to be used for transactions, only to find that to the extent that they actually are more than 1 or 2 pages and a back of an envelope type arrangement, even if it's a proper contract, then it still sometimes doesn't have all of the right terms so that it fits in with the financing, usually because there's no reason why it should. It may have been a pre-existing arrangement or pre-existing terms that they'd worked on before, and the financing has come in and is trying to overlay that. So it's partly our job to make sure that any contracts we look at fit with the transaction. You've got the price risk, price fluctuation. Can it be a fixed price contract, so you have guarantees, or does it have to be spot rate? Is it benchmarked against some sort of exchange price to give an element of comfort? If not, then maybe you can have some sort of hedging in place or some sort of security margin arrangements, such that if the value drops when you look at a particular market price, that the obligor has to provide more security for you. There's also the issue of what happens if the product isn't quite at the spec in the contract. For some products, oil notably, but also some agri, there's a possibility of having price adjustments rather than refusals. So again, to the extent those sorts of remedies are available, then you can try to include those in your contracts to alleviate that sort of risk. And then obviously, lastly, you've got things like exchange controls and repatriation requirements and the extent to which they may impact on the ability for export proceeds, sale proceeds to be sent direct to a collection account which is offshore, which obviously would be the ideal situation. So there's some of the risks associated with the buyer and the offtake contract. But there are also risks associated with the different commercial stages of the transaction before you even get to the point where the buyer is obliged to make payment. And as I said, these revolve around the third parties involved. We're going to look at storage in a bit more detail later on. So I'll concentrate on the other two there for now. Obviously, for both of them, there's the potential for fees to be payable and for those fees to result in a lien over the goods that they're either transporting or processing. How do you deal with that? You can either arrange in the documentation for any liens to be waived, or to make sure that as part of the financing process that those fees are paid out of the money is drawn down on a regular basis, so that you can be sure that they have been paid. We did have a transaction once where it went into default and those fees hadn't been paid, and the bank, just when it was trying to enforce it, couldn't do so, and it had to end up paying the fees for the warehouser before it could even access the product, which is not difficult. Sorry, which is difficult if it's in a far-flung emerging market country with difficult access. So it's something to make sure it's dealt with, if at all possible, up front. In terms of both of them, again, you have the issue of loss of control. Different perhaps to being in a warehouse when goods are being transported or processed. How do you maintain control over that, especially if you were expecting to have security over the asset? It's a bit more difficult with a processor, but presumably there will be agreements in place where if it was that important and there's that much of a risk, then assignments of those agreements can be taken to create some form of liability on the processor, and you can have direct undertakings from them, assuming they are willing to give them as part of the transaction to try and alleviate that risk. Same with the transporter. There'll be a transport agreement and there may well be rights under that. In terms of the transport, there are also issues around loss of product, theft, that sort of thing. And how would you deal with that? I think those issues apply across the board, although perhaps less likely in terms of theft in relation to oil, perhaps if it's being transported by pipeline. It does happen, but it's less likely to happen than with road, rail, etc. types of transportation. And obviously there's the commingling risk, which again is more prevalent with oil, or perhaps some agri products, where it's difficult to separate them during transportation unless you happen to have bought the whole mass of the product being transported. So in terms of potential mitigants, we're going to go through those now for the third parties, and we're also going at the same time to lead on to looking at security and insurance before finishing up in this part of the talk by looking at the terms of the actual agreements and how they can help with this. I suppose one last point to mention in relation to commodities and how they differ is that some of them will throw up risks that the others don't. So for example, obviously, if it's agri, then you have the potential for either bad crop seasons to apply. You've only got seasonal production and sales. So if something goes wrong, you have to reschedule, then you might not be able to produce and sell more product straight away. With the agri, you've obviously got the risk of perishable goods if there are problems and you're having to try and restructure or enforce. So again, trying to limit tenors or payment periods for those types of goods so that they, even before they've gone wrong, there is a limited time for them to be sold so that you know that even if you do have a problem, you'll have a bit of a buffer period to try and deal with them. And then lastly, obviously, you have some environmental issues relating to certain goods, which are going to be difficult to lay off unless you can get some form of insurance. Although obviously that's going to be perhaps a worse position in the ownership structures than in the lending structures. But people still take the view that lenders have deep pockets. So it's always a risk, even if you don't in the end up having to pay out. There's still a process which would be painful to go through. So who's involved? As I said, most transactions of the sort we're talking about here, and I'm looking particularly at things like warehouse financing and shipment financing pre and post, and transportation generally, you're looking at these types of entities. They all have the general issue of fees and liens, as I mentioned earlier, but they can also help. And warehouse owners, for example, they can play an important role in evidencing the existence of goods in warehouses, collateral managers and stock monitors as well. And as we'll come on to a little bit later, it's a slightly different role. The stock monitoring really has relatively little assistance for financings compared to collateral managers who can provide real-time information in relation to products, either when being transported or being stored in warehouse. They can look at quantities and qualities, valuation calculations and the like. They can also provide control, provided they have been given that by the warehouse in question. And that's where one of the main differences between the two come up. So we'll be looking at that in a bit more detail. In terms of the account banks, they've been included there mainly because if you are a bank that's funding a deal, then you're more likely to be the account bank for the collections, and that's fine. But if you're not, and you're a fund or some other form of financial institution without deposit-taking abilities, then the bank account will be somewhere else. If that bank account is in the name of the customer, the borrower, then there's always the potential, if there is any money in there in a default scenario, for you to have difficulty in accessing those funds without some sort of express instruction from your borrower. We looked at a deal recently where that instruction was not given. It was ultimately waived by the institution in question. And that was all fine until the transaction went wrong, and the bank, which was in the Middle East, would not give access to funds, even though they'd been told there was a pledge over the account. Even though they could see the pledge, they'd not had a formal instruction, and therefore were not prepared to release any funds, even though they accepted that they may ultimately do so as part of an insolvency process. The only way to deal with that is really to make sure you get those instructions and those agreements from the account banks up front, unlike in that situation, or to have the collection account in your own name, so that any monies coming in go into your own named accounts over which you obviously have control, and then the documentation will deal with how that money finds its way back to the borrower as and when it should do so. Just a slide quickly to give an idea, just a flavour of the potential here for different countries' involvements. Obviously, you have the lender in country E lending to borrower in country A. They're supplied by country B. They're shipping to country blocked by my C. And in the middle of all of that, there's another processing stage happening in country A. Monies are then paid to the buyer, sorry, by the buyer in country D back into country A where the bank account is. So lots of different countries involved there, lots of potential for local law issues, for conflicts of law issues. So it's really just to give you a sort of a flavour to understand how complex these things may well be. And whilst I'm not going to look in detail at logistics providers in this session, it's worth noting that we are more and more seeing financiers bring in logistics providers to essentially run this whole process. So from the point in time when the money is advanced, the logistics provider will perform a number of different roles. It will perform the collateral management role, perhaps even the warehousing role, certainly the transportation role. It will be making sure it has control in some way, shape or form throughout the commercial process, rather than a financier having to rely on any individuals at each stage to sign up agreements with the borrower and the bank. So it can make things a little bit easier, but we are only just starting to see that sort of comprehensive approach being taken. So in terms of storing the goods, warehouses, the first thing to ask is, whose warehouse is it? Is it a private warehouse? In which case, is it the borrower's warehouse or the borrower's group's warehouse? Or is it a third party? Is it public? Is it regulated? Which in many ways is very good. And we'll be looking a little bit later at warehouse financing. But essentially, because they're licensed and regulated and potentially part of a national program, it may be possible to take a lot more comfort from that. But I think certainly in terms of the private warehouses, which is most of mostly the case in the transactions we look at, it's a case of, is it third party independent or is it obligor owned? And if it's obligor, then you're certainly having to look at things like collateral management arrangements being put in place to make sure your position is protected. If it's a third party, you may be happy to rely on that third party by taking certain covenants from them if you take an assignment of the warehouse agreement or become party to it. Or you may just want to put in place a stock monitoring arrangement rather than the full-blown CMA. Now, in terms of the issues around goods, I've listed three here, which in some way, shape or form find their way into a lot of the structural approach that's taken. The first two a little bit fit together, and here I'm talking about if you don't have the ability to control the goods, or obligor parties have the ability to interfere with those goods, or because of a lack of control, they're open to fraudulent behavior. These are all risks relating to the goods that you have to deal with. You can't really document against fraud. All you can do is document to make sure that your monitoring is up to scratch, that you have third parties in there that you have agreements with and who are liable to you if things go wrong, in order to try and put back in place that level of control. Otherwise, it's very difficult to deal with the fraudulent side of things. And these are the main risks during storage. Likewise, loss and deterioration. Can you get insurance for that? Have you done your due diligence on the warehouses to make sure that they're up to scratch and that they're required to maintain certain standards, that they perhaps have PI insurance standing behind them? So those are the sort of things you can do. But ultimately, the extent to which you want to have protections in this regard is a cost reward question. You can have the most comprehensive collateral management arrangement or even logistics service provider arrangements in place, but it will cost you, and you really do get what you pay for. So I think it's very important to understand at the outset the level of risk you believe is involved, because if the cost is too high for the transaction, it makes it financially unviable. But at the same time, you don't want to just go with something that's a cheaper option to get the deal done and make it financially viable, if that then leaves yourself open. So it's a bit of a balancing act, but as I said, it's very much a cost reward basis. So looking at storing the goods, you need a satisfactory agreement. You need to make sure that the scope of the services is correct. That ideally, if you're taking security, say by way of pledge, that it covers enough to give you perfection of your security. You need to know which entity it is that's going to be liable. Quite often we see agreements where it's an umbrella agreement with a particular collateral management group or stock monitoring group, but actually it's a different entity on the ground that's doing the job, and the liability needs to be with the main entity that's party to the agreement, that they can't just subcontract it down and absolve themselves of liability. Very important to double check that. And obviously they have to provide sufficient control over the goods as well, to make sure that they're not released without the financier agreement. Monitoring and control, they need to be on site. They need to be checking. If you've got a CMA, it needs to be regular. It needs to be reported regularly. They should be issuing receipts, or at least checking receipts that are issued to make sure they comply with what's actually been put in the warehouse. And they'll be controlling release and liaising with the financier all the time to make sure that they're kept up to date in real time. There are practical issues as well. The entity that's doing the collateral management or the warehousing, from a practical perspective, they have to have the staffing, the expertise, and the resources to be able to do it to the levels that you require. But also you need to make sure that there is a reasonable amount of rotation in staff if they're locally hired, to make sure that they're not susceptible to the influence of the local borrowers. So just a practical thing there to look at. And also to make sure, obviously, that they have PI cover themselves, so that if there is any liability, that they have the wherewithal to cover that liability. Oh, gone one too far. So I said I wanted to touch a little bit on security. This is really a list. I'm sure you've all seen this sort of a slide before. It's really just a list of things that you need to check to make sure that your security works, and that it's appropriate for the transaction you've got, that it covers the right asset, that the owner of the asset is the one giving the security. We've certainly seen before situations where there've been intra-group sales, and the wrong group entity purports to give an assignment over contracts, or purports to give pledges over goods when actually they're not the owner based on the intra-group transfer arrangements. You need to know the asset exists. You need to know where it is. Does the documentation sufficiently identify it so that the security works? And sometimes this will be local law questions as to what's required. It's not everything is available everywhere, and different laws will have different requirements for it. Some will allow you to just reference, for example, a silo for grain, and anything in there would be secured, and that would be fine. Alternatively, some others require specifics about the grading and the specific quantity of product. So you do really have to do your local due diligence, local legal due diligence, in order to make sure you understand the position. you've got to look at who might have rights to those goods if it's not the owner. Are there any liens? Are there any prior ranking security interests that would apply? And even things like strategic reserves, which would prevent certain quantities of product, oil's an obvious one, from being exported because it's part of that strategic reserve. So as I say, very important to do the due diligence locally. It can be time consuming, it can be costly, but that's in the short term. In the long run, it makes a big difference potentially. So what I want to do now is look at the types of security you would have in relation to goods and the differences between them and some issues around them. The main two, certainly from an English perspective, is proprietary security, which is something like a charge, an encumbrance over the asset, versus a possessory type security, which is like a pledge, an English law type pledge. They have different names in different jurisdictions, but essentially those are the sorts of things that we're talking about. So in terms of the proprietary, what we're looking at there, as I said, is the charge type security. It may be that the asset is not one that you can take possession of for some reason, and therefore this is all that's available to you. Formalities are a bit more usually, so there's certainly usually registration requirements to be gone through, and if you want to enforce, there might be certain requirements for things like court orders or public auctions and things like that if you want to enforce that sort of security. There's also the potential for competing interests. If you're registering security, as is the case for English companies here, there may well be more than one security document over a particular asset, and so therefore they will be ranked. So important to find out if that's the case. Not everywhere has to register these sorts of security interests. So you do wonder in that case how the security works, because obviously the registration is supposed to give notice so that anybody coming in afterwards knows that there's prior ranking security. If that doesn't exist, then it seems to me that this sort of proprietary security has a fatal flaw in it, because you have no idea whether or not you have prior ranking or not, because there's no public register to search. And that's the case in a number of emerging markets, and particularly places, like some places in the Middle East where there is not a publicly available register, even if there is a register, and you have to jump through a number of hoops to be able to access it. One other thing to bear in mind is that we did come across a situation a few years back where they had the particular jurisdiction had wonderful security registration rules, and they worked very well on paper. You had a document that would work with them. The only problem was there was a registration requirement, but they hadn't physically constructed the registry. So you could never comply with the requirements, and you could never have effective security, even though they had this wonderful piece of legislation setting out a very good regime. So again, lots of things that can go wrong, lots of things that need to be checked locally to make sure that your structure will work. No, apologies. In terms of possession, as I said, we're talking here about pledges, which generally speaking require an element of a sufficient level of control over the assets, whether that's actual possession, constructive possession via a third party. You do need it. And there are usually fewer formalities to comply with in order to achieve that security. So it makes life a little bit easier. And also on enforcement, it should be a little bit easier, because you're more likely to be able to employ self-help remedies and avoid the courts. Again, very difficult to have competing interests. It's possessory, so only one party ought to be able to possess the goods at any one time. So that's a risk that ought not to apply if you take possessory security versus proprietary. I've mentioned on the slide here about attornment, and that's a formalized process in order to achieve the constructive possession over products held by a third party. So if you're looking, for example, at goods in a warehouse, you would need the pledgor to instruct the warehouser, for example, to issue a warehouse receipt in the name of the financer. The warehouser would then obviously need to issue that warehouse receipt to the financer. And then the third step is for the warehouse to confirm in writing that it holds the goods to the order of the financier. And if they do those three things, then the interment should be successful and should provide sufficient constructive possession to perfect the security. This can equally be done by a collateral manager, and if he's responsible for issuing receipts at a particular location. In terms of the arrangements with the collateral manager, they obviously should be following the instructions of the pledgee only. There shouldn't be any risk of the goods leaking out without the bank's consent. And it may be that in order to give the level of control, because this is a separate aspect to the interment process, because if in practice they don't have possession and the control aspect isn't there either, then there could be issues. And that's very much going to be a local law question as to what's required. But the sorts of things that are likely to be relevant factors in that, whichever jurisdiction you're talking about, are things like segregation, having sole access to the products in the warehouse location, either sole use of the warehouse or some form of lease for a designated area which is under lock and key, and potentially some form of labeling. These are all factors that are likely to be taken into account when the decision is made on a case-by-case basis. So I want to look at what happens in fungible goods, commingled goods quickly. The ability to take security over future assets depends on the type of security you have. For example, with an English law pledge, because possession is a requirement for pledges, then obviously you can't take a pledge today over assets you don't yet have. What you can do is take a pledge today which refers to a identifiable group of assets which may change over time. So for example, I pledge everything that is in silo X to the bank from time to time. Then as goods come and go, then the pledge should bite each time the goods go into silo X. That's not the case everywhere. In some jurisdictions, notably civil jurisdictions, you have to provide a new pledge or a new letter confirming the pledge each time there's a new batch of goods, which is obviously not very helpful from a practical admin perspective. In one jurisdiction, in Turkey, they brought in a law relatively recently where they purport to give you the right to take a pledge over future assets, but it's not quite sure yet how that works in practice, and there doesn't seem to be any guidance or precedent on that yet. But the point is there's a variety of approaches being taken. In terms of fungible commingled goods, again, there are a number of different approaches. For example, in the Netherlands, if there are commingled goods, then you would tend to get a pro rata share of those goods if you have security. In South Africa, you might be able to use a general notarial bond to be able to take security over these types of goods. If the reason for the commingling or the result of it is that there is a new product through some form of processing, then you need to be careful about that, because your pledge may well bite on, in my example, anything in silo X. But if the anything related to a set of goods that were described and they were the raw material pre-processing, then when the processed goods comes back into the warehouse, there's a risk that the pledge will no longer bite, even if they're back in silo X, because they are a different type of good. So you need to be careful about drafting the security document to make sure that it takes into account the processing so that any new product is also covered. Lastly, in this section, I just wanted to touch on liens and trust receipts, etc., as shown on the slide. The liens don't give a right of sale. They really are just more like, if you like, a bargaining chip to receive payment. They're unlikely to be part of a financer's package, but they are, as I said earlier, something to take into account in relation to third parties, because they may well cause problems when you're trying to collect your cash. Trust receipts, in order for those to work, certainly from an English perspective, you need to have a pledge in place. Sometimes goods need to be released in order to be sold to generate the proceeds of sale. So they need to be released from the pledge for that purpose. You can have trust receipts issued. Those trust receipts essentially mean that once the goods are released, the borrower who has taken them to sell them is holding them on trust. And if they do sell them, that any sale proceeds are equally held on trust for the financer. And if the goods are not sold and returned, that the trust receipt and the pledge in combination, which is why you need the pledge in the first place, returns the goods to the security created under the pledge. Doesn't work everywhere. You'd have thought places which didn't recognize trusts would have an issue with that. Most do, but some don't. The UAE, for example, has the concept of trust receipts, albeit in a slightly different way. But whilst they don't recognize trusts generally, they do recognize them in this particular context in certain circumstances. So again, check out with the local lawyers. On bills of lading, how do they work? I'm sure we all know how they get issued by the ship's master. The three sets of originals. The controversial question, I suppose, is whether they're documents of title or not. I think it's fair to say there is a potential difference of opinion. Certainly, from an English law perspective, hundreds of years ago they were. Legislation has been brought in the last 70, 80 years or so, which has thrown a little bit of doubt on that. I think certainly what they give you is the right to possession. But I think the issue is whether or not it gives you right of ownership to the goods, whether it gives you title if you transfer those documents. I think if you have a pledge over goods and documents, so for example, a pledge whilst goods are on a ship, then as the holder of that pledge and as the holder of those bills of lading, you have the ability to go and get the goods off the ship, and then you have possession of them and have your right to sell under the pledge. So from a practical perspective, there may be relatively little difference as to whether or not they are negotiable, whether they are documents of title or not. But certainly in order to be documents of title that could be transferred, they would have to be negotiable. And they're only negotiable if they are held and issued to the order of a particular party or its assignees. If it's a pure consignment to one named entity only, then they would not be negotiable, and therefore the question is a little bit more academic. And then the last section on title and risk passing. Here, what I wanted to raise was why this is important. And it comes back to one of the questions I asked earlier, which is who owns the asset? If goods are, a title to goods is passing when goods are on a ship, you need to ask yourself, well, is that at the beginning of the shipment or when they reach their destination? And the obvious reason for that is who owns the goods. If title is transferred whilst they're on the ship at the outset, then you don't require security during the voyage, because presumably under the contract of sale, you have a payment obligation on your buyer. If they don't transfer until they reach their port of destination, then your borrower is potentially the owner still, and therefore a pledge may well be important because you don't yet have that payment obligation, and you run the risk of losing out if you don't have all the protections in place in relation to those goods, things like insurance and effective security whilst those goods are on ship. Now, title passes under the terms of the contract. It doesn't pass under the terms, the Incoterm that they're being sold under, which is a common mistake. So it's very important not just to look at what the Incoterm is that's being used for shipping, but also what the contract says about the passing of title and even the payment, because it's not always the case that payment is required in order for title to pass. It may well be at a later date or even an earlier date. So again, you've got to check all of those things. And one extra point is there any sort of retention of title arrangement in the contract of sale, allowing the goods to revert back if title is passed before payment has actually been received? So I'm now looking at warehouse receipts, and what I wanted to do here was just look a little bit about warehouse financing. I'm not going to run through this slide, it's self-explanatory, apart from the last bit where in terms of the format of the receipts, there are some jurisdictions which require a particular format in order for them to be negotiable and transferable. And it may well be that in any event, there is some local legislation or private regulation, and here I'm thinking about warehouse programs which might not be at the national level, but are done at a sort of members level, which specify certain formats. So that's something again to look out for. So financing, you can finance against warehouse receipts in some jurisdictions where they have certain rights. Not all warehouse receipts, as the previous slide said, are documents of title, but some are and can be financed against, even where that position has come in at a national legislation level, but also if it's coming at a private club approach level. Even if you have goods in a licensed warehouse and you have warehouse receipts issued with valid pledges to perfect collateral, you still need to comply with local law issues though. So whilst you may have complied with the atonement process generically, there may be additional points to comply with in order to make sure that your collateral still works. You want to make sure you've got rights against the warehouse operator and anybody else who might claim an interest in the goods. And I think in terms of things like private platforms or private club arrangements, that's fine until you get to the point where there's a third party involved who's not signed up to the club, and they are starting to have or purport to have claims in relation to goods. At that point, you have to look back to what the local law position is in relation to those goods, because obviously that third party is not subject to the club arrangements unless they've been brought in by national legislation. One of the critical differences with a warehouse program which allows for these sorts of financing arrangements to be put in place is that they ought to give the financer the ability to avoid court processes, avoid public auctions in order to dispose of any secured goods. They ought to be able to go straight to the person, the entity running the warehouse arrangement, claim their goods and go and sell them as they wish. But the important point is that there are systems in place to achieve this, whether they are national or at club level. And here, this slide really just sets out some of the requirements which have to be in place in order for these types of financings to work. It's a fairly obvious list if you look at the key elements that a lender would require. Essentially, they allocate risk. But I think from a lender's perspective, it's not only crucial to have the right rules in place and the right systems in place for these things to happen on paper, but also it's important to make sure there's somebody taking liability and standing behind this. And so the bottom of the slide there, which talks about the warehouse performance and the fact that there are indemnity systems and perhaps even insurance arrangements standing behind the performance of the warehouses, so that if they're negligent or fraudulent, or even if somebody else is fraudulent and the warehouses should have been able to deal with it, that there is an arrangement standing behind the warehousing system to make sure that the finances can be kept whole. So having looked at security in these sort of financing arrangements, is security the answer? Well, it's, you often get told, well, we've got security, so I've got to have a good deal. And that's going to be how I get paid out if things go wrong, which, as we all know, is not really the case. And even if it is the case, there's bound to be huge costs and delay involved. And quite often, there are other ways of dealing with these issues. And so what I'd like to do now is spend a bit of time looking at the alternatives. So you use the documents, look at your documents. If you've got good documents in place from the outset, then they should help you in times of stress to make sure that you can be repaid. You can use the parties that you've locked into the transaction and their agreements to help, to make sure that ultimately what you want to do, which is keep the goods moving, have the goods delivered so that the end buyer has to pay, that all of that can still take place, even if there are issues with the borrower or defaults, what have you, that there are alternatives to just going down the enforce your security route, because the likelihood is that if you get to that point, there's very, very unlikely to be anything in the collection account. There's very unlikely to be any goods around anywhere. There might be some, but certainly not enough to cover the exposure. So use the documentation, use the rights you have under the documentation, under the assignments of those documents with the commercial parties to make sure that the process keeps flowing. They can help, if you've built in flexible terms and you have rights against those parties to make them do certain things in certain situations, you can keep the thing flowing. But in order to do that, you really do need to have good monitoring and good access in place so that you know either before things go wrong or as soon as things go wrong, what the position is, that you have the right triggers in place, whether that be cover ratio tests, security margin tests, blocks on drawdown, just to make sure that the position is not made worse and that the self-liquidating nature of the transaction can play out. And then there's ownership structures. And what I'd like to do with the remaining part of the talk is look at repos. I'm sure we all know what a repo is, the forward sale, or sale rather, and repurchase of a commodity by way of some sort of forward sale agreement at a future date. I suppose in terms of the agreement, the question is, should that document be, the repurchase document, be an obligation on the original seller to repurchase, or should it be an option for the seller to repurchase? And that may well come down to whether or not the seller requires it to be off balance sheet, and whether or not it has an impact on the true sale nature of the sales under the repurchase transaction. Why they're used, as I mentioned, sometimes the counterparty wants off balance sheet treatment, so they're looking for that, and they don't have any limits left. It may be that the bank doesn't have any limit left internally, but wants to continue to be financing a particular client. So it works both ways. But the third and fourth one in the list there are really for the bank's benefit. In certain jurisdictions, it really would be easier to recoup your exposure if you are the owner of the goods rather than a secured creditor. Security may not be available. It may be something that's probably not enforceable. It may be that the process of enforcement, if it's court orders and public auctions, would just prove too much of a delay and too much of a risk on what you would recover, especially if they're domestic auctions only, because you're much likely to get a much lower price. Self-help remedies would be available, so you can just go off and sell the goods externally if you have an export license, and hopefully recoup a lot more money than you would do if you were just a secured creditor. So that's the sort of the rationale in a nutshell for them. And there's just a couple of diagrams. The first one's a basic repurchase diagram. So you have the sale of the commodity, and you have the repurchase, and you may well have a sort of a standby, whether it's a third party or some form of exchange that you would sell to if the repurchase doesn't take place. And that would be particularly a possibility if it was only an option of the counterparty to repurchase the commodity. On a slightly more complex basis is where you have goods in a warehouse. And in this case, again, you would have the sale of the commodity. You may well, if they're storage, have the storage provider giving you some sort of warehouse receipt or title document, as perhaps even as part of an internment type process, not for security reasons, because you're obviously not taking security, but just because you want to make sure that they've issued you something that evidences your ownership of the goods. You may well have the counterparty acting in some form of service capacity, so that they're taking care of storage and on your behalf, on the bank's behalf, for the period of their ownership, and essentially dealing with the warehouse as if they had remained the owner. There's got to be careful about that in the context of true sale, and we'll come on to that in a little while. And then lastly, you have the option or obligation to repurchase in the same way. So what are the risks for the bank? Because it's clearly not a risk-free structure, otherwise everybody would be doing it all the time. The financier is the owner of the product, and there are potential issues around that, not least potential environmental issues, especially with certain products like oil. You potentially have price risks, and we'll come on to that later in the context of true sale. It may be that for some reason the institution cannot be an owner of goods for internal compliance purposes or various purposes. In that case, they may well want to use an SPV. Certainly, we've seen a lot of institutions use SPVs as the conduit for repo transactions, the SPV being funded on a limited recourse basis by the bank. The question is whether they set that up as an orphan SPV so that it's completely independent, which helps with things like potential ownership type liabilities and shadow liabilities, or whether it's an in-house where the bank just basically owns the entity that carries out the repo transaction. So again, very much a case of costs as well. A bit of a balance to be struck there. I've shown some things that the SPVs are used for. Obviously, the first one is in the case of the repos. Sometimes they're generally just used for ring fencing of assets. Sometimes they're used to be offshore and avoid exchange controls if they can receive export proceeds offshore, whereas it would not otherwise be possible to do so because the borrower has to repatriate. Or they may be a standby purchaser if the repo doesn't happen and it's a repo with the bank as the owner. So lots of different potential uses for the SPVs. Looking at a few more issues that the banks need to look at. Also, I mentioned price fluctuation. You've got delivery and storage costs, which all need to be taken into account in the pricing. Insurance obligations. And again, when we come on to look at the considerations for true sale, you need to be a little bit careful. There are mitigating factors that you can use to help with these situations, hedging potentially on the pricing, passing through the costs through the purchase and repurchase price arrangements, and obviously collateral management to help with any risks at the storage stage if the transaction is one of like the second diagram where the goods are being stored. But by far and away, the main issue for the banks in the ownership structure is the question of true sale and the recharacterization risk. Now, what we're talking about here is the recharacterization by the courts of the repo sale and repurchase arrangement as a loan, essentially. As it is unlikely to have been structured to have any form of security and certainly not registering security, then any recharacterization as a loan would mean it was recharacterized as an unsecured loan unless there was the ability to take fallback security. That's very rare. You can do it in the US, but there are very few places where you can have that sort of security so that it's a sale and purchase unless they hold it's a lending, in which case your security bites at that point. Certainly from an English law perspective, that would be pretty fatal to having a true sale type structure. So looking at true sale and recharacterization, this really sets out the English law position as to when it would and would not be recharacterized. English law is very flexible on this front in terms of the way it approaches the question. I've got on here a quote from a case, which you can read yourselves, but which shows that there is that level of flexibility and that you've got to look at the transaction as a whole to determine whether or not it's a sale or a lending arrangement. And what that case held is that the intention of the parties is critical in coming to that decision. Now, having said that it's critical, it's by no means the only factor that would be taken into account. And indeed, no one factor is likely to be decisive in this matter. So what I think you need to do is look at all of these different things. And I've listed points here which, if they are followed, should mean that there is a negligible risk of recharacterization. But they are things which a bank, in many cases, would not ordinarily do. So whilst the bank may well have the intention to have a sale arrangement, and equally the seller would have the same intention, and you can document that and say it's a sale, which obviously helps and is not really an issue, a risk issue for the bank. Some of the others are. So if we just take a quick look at what they are. For the option obligation, I mentioned earlier that may potentially have a bearing on the true sale nature of the transaction. If it's an option to repurchase, even if it's an option sorry, if it's an option to repurchase the goods, then that's much better than if there is an obligation to repurchase the goods. That sort of resembles more a loan agreement than the option scenario. Than the option scenario. Even if you have an obligation with a third party that is a group company, that is far better than just having an obligation on the original seller to buy the goods back. Again, it's not necessarily conclusive, but it's a better position. So you have that sort of three ranking. Option is best, obligation to group company or third party, and then obligation on the seller to look to. But it doesn't necessarily mean that in all circumstances an obligation on the original seller would be decisive. In terms of insurance, this and the rest of the entries in the list are really looking at who is acting as owner here. Is the bank acting as the owner of the goods and taking the normal ownership risks in the goods and dealing with the goods as you would expect an owner to have? So is the bank the co-insured under the insurance, or is it the insured as opposed to being loss payee with an assignment of insurance proceeds? Who's arranging the insurance? Who's paying for the insurance? In terms of the storage, does the bank have a direct relationship with them? Beware here of having indemnities that are far too wide against the storage provider. That's not helpful. And likewise, having too wide indemnities against the seller is not helpful at all. On the price risk, they've got to take the price risk really, but they can mitigate that, and that doesn't necessarily go against them because they're mitigating that with a third party, so they're still taking risk on that third party. And in terms of the damage and loss risk, again, who takes that? If you just pass that risk back to the seller, then it's going to be much more difficult to believe that it's a sale and purchase arrangement rather than a lending. But essentially, the bank has to remain the decision maker in all of these things, even if it uses the seller as a service provider to liaise with different commercial parties. The bank has to be the one taking the decisions, and if it does, then it's much more likely to be seen as a purchase arrangement. So that's really a sort of a flavour of the factors that are relevant to the question. The last point really to talk about on this is transfer of title. Obviously, title has to transfer. It's very important for title to transfer as part of the sale arrangement. Some might say it was even fundamental to it being treated as such. If you can get title documents to whatever the assets are, that's obviously the best thing you can get. If not, have some sort of evidence, whether it's warehouse receipts, bills of lading, something that evidences that you are the owner of the goods in theory. The document needs to evidence that title passes at a particular point in time, and there has to be delivery. Whether that delivery is physical or by way of attornment, it needs to take place in order for title to transfer and therefore for the true sale to happen. And it's not just the document that is important, it's also the local laws are important. You should get local law advice as to what's required in the jurisdiction where the asset is, because it may be that they have other issues that are required to be complied with in order for the sale to happen, the title to pass. And they may, even if it does pass, there may be regulatory or environmental issues that you need to know about in order to take advantage of the title passing and the sale and purchase arrangement. The last aspect of this slide is really looking at potential different scenarios, just some examples of when title might transfer under your documents, and I'll leave you to read those. But I'd like to end on this point really by just looking at commingling and the impact of commingling of assets at the point of purchase. And in some places, this may well prevent the transfer of title, certain civil jurisdictions in Europe, for example. And it's obviously more problematic for something like oil because that's much more likely to be commingled. In terms of how you deal with that, then certainly you could ensure that the product was demingled, for want of a better word, at the point of transfer and then commingled again afterwards if that's what needed to happen. Maybe you buy the whole mass of wherever the goods are stored so that there is no commingling, it's all yours. Maybe you can get some reps or some covenants from commercial parties, whether it's the seller or the warehouse operator, in relation to the fact that the goods are not, so that if they are, it gives you additional claims against other parties. But the best solution would be to make sure you take title of the whole mass of the goods in question, so there's no commingling issues to talk about. And then I'd just like to finish up the session. I know Jeff's come back on, so that's my warning shot, by looking forwards really to a couple of things to do with electronic bills of lading, warehouse receipts. Most jurisdictions recognize paper bills of lading, but there are a lot of issues around electronic bills of lading. Certainly, in order for them to work in the same way as paper bills of lading, there's the technology side of things that have to be in place to make sure that data is transferred securely and safely. But just as importantly is making sure that a wide variety of participants take up the technology. So you've got to have, if you want to do one of these transactions, if you remember back to that earlier slide in the number of parties involved, there'll be financiers, there'll be borrowers, there'll be traders, there'll be insurers, there'll be carriers, warehouses, collateral managers. In order to make these things work, you may well have to have a number of them signing up and being party to these arrangements in order for the transaction to work and the electronic bill of lading process to be sufficient. Additionally, the legal regime has to be there. You've got to have certainty of the legal status of what is being done and that the transfer works from a legal perspective in the relevant jurisdictions. I think at the moment it's safe to say that whilst the tech side of things is there or pretty much there, the legal regime is lagging rather behind significantly. And there's a quote here on the slide from a judge here, which I think puts that in perspective. There is a model law which has been brought in by UNCITRAL, but the take-up has been very, very low and likely to be very, very slow going forwards, which means it's not really going to be a significant factor, albeit it may well prove to be a good starting point if people do sign up to it. The alternative is national legislation. Really, a lot of jurisdictions have national legislation dealing with electronic products generically, but very few, in fact, possibly even only the US and a few others have specific legislation dealing with electronic bills of lading. So it's a very difficult process to rely on at present, and is very much a watch this space. The difficulties from the legal side are that in order for the three functions of a bill of lading to apply, there has to be some sort of equivalence with a paper BL. And in order for that to happen, the holder needs to be in the same position as a holder of a paper bill would be. And there needs to be only one such holder. It has to be unique because that's how it would work with a paper bill. In the context of a financing, it becomes even more complex. And if you don't have substantive law, as we don't, then really the only way to try and deal with this is through contractual arrangements at present. You may well be able to get some help through an acknowledgement from a carrier that they will be holding it to the order of the person with the BL. But if there's no underlying contract with that carrier, as there would be with the original recipient of the electronic bill of lading, it may well prove difficult to enforce that. You may well have club arrangements where groups of people get together and they agree to certain rules applying. And that's fine as far as it goes if those rules work. But as soon as you have third parties making claims, as I mentioned earlier, it becomes a lot more difficult to say that the rights of that third party under whatever the relevant law is does not supersede the club arrangements which have been privately agreed. Equally, if you want to transfer out of the club to a third party, you have to convert to a paper bill, and that has all sorts of problems. You know, what's the date of that bill, and does the recipient have the same rights as the person who would have received an original paper bill at the outset? It's still not clear. So as I said, work in progress. In Singapore, there have been recent advances. There's a thing called the e-title authorities, which are making progress. But overall, legal is a long way behind and needs to catch up before it can really have a significant impact. And we're really not there yet, but at least moving in the right direction. And I think given the time, I'm going to stop there. There was one more slide on electronic warehouse receipts, but it was really just to say that UNCITRAL and UNIT are looking at trying to bring in a model law as well. but that is a number of years off yet. So you're really looking at domestic legislation and programs to achieve that. We have one here in the UK, which is the LME Shield mechanism, and that is a specific regime for warehouse receipts, which allows pledges to be taken and dealt with. But the LME has always been far ahead of the game in these things anyway. So I think a much wider take up is required before it's going to have any significant impact. And with that, I will pass you back to Jeff to see whether there are any questions.
Simon, thanks. That was a pretty intense go through, covering an awful lot of areas. It was good of you to sort of whet the appetite right at the end, because one of our future seminars in the next couple of months will be on digitization, and we'll start looking at a bit more detail. We've had a few questions, but they're quite sort of technical questions, and we really are out of time. So I'm going to invite Simon just to give sort of one-line responses to those who've asked the questions, because they're sort of technical questions, and a lot of it was actually covered in the subject. So I hope that was a good, fairly deep dive in some areas, and we've covered a lot. Thank you all for staying attentive all the way through, and I will give you back the rest of the day with, again, thanks to Simon. And we look forward to seeing you on the 25th of March, same time, if you like, the same place, on receivable structures, to see if we can help on that side. So with that, happy structuring and happy deal doing. Thanks very much.